My name is Terrence Barkin. I'm the Executive Director of the Graphene Council, and we are hosting today's webinar on Graphene IP licensing as a business model. And we are very fortunate to have a pair of subject matter experts on this topic from the law firm of Potter Clarkson. We have Jason Tang and Dave Holt, who will be doing the presentation. For those of you who do not know about the Graphene Council, we are a global independent trade and professional body for the sector. We connect more than 30,000 material scientists with professionals and engineers who have an interest in graphene and other advanced 2D materials. And our mission is to help with the commercial adoption and exploitation of this material, whether you're a graphene producer, an intermediary company, or an end user, or a researcher. And with that, we're going to go ahead and get started with today's presentation. So with that, I'd like to introduce Jason Tang and Dave Holt. Gentlemen, it's all yours, and we look forward to hearing from you on your insights in this really important topic for the graphene sector.
Thanks very much.
Thank you, Terrence, and hello, everyone. Obviously, thank you to the Graphene Council for inviting us to talk about graphene IP licensing as a business model. So, by way of background, from when graphene was first isolated in 2004, the industry has grown in leaps and bounds to what we are seeing today, scalable graphene production ready for commercialization. The challenge facing the industry now is identifying key products and applications for the graphene that is being produced, which brings about opportunities in licensing graphene IP to third parties looking to jumpstart their own graphene commercial activities. My colleague Dave Hall and I are here today to talk about IP commercialization and risk management in the graphene industry. Before we start, we would like to give a brief introduction about Potter Clarkson and ourselves. Potter Clarkson is a full-service IP law firm of patent and trademark attorneys and IP solicitors, and we provide legal services on a pan-European basis with a strong focus on the UK, Sweden, and Denmark. Now, whilst our main areas of practice are in UK and European law, we have an informal global network of associates with whom we work to help our clients with their global IP strategies. And our clients come from a range of technology and business sectors, ranging from startups and early stage companies to SMEs to multinational corporations. Our patent attorneys work across a wide range of technologies, including advanced materials. And our trademark attorneys work to protect and enforce our clients' brands from their competitors. Meanwhile, our IP solicitors are experts in drafting and negotiating all types of IP agreements, carrying out IP due diligence, and handling IP litigation and other contentious matters. Potter Clarkson is also a member of various technology networks and organizations, including the Graphene Council. I, Jason Tang, am a partner and patent attorney at Potter Clarkson, mainly working in the fields of physics, engineering, and advanced materials. Prior to joining the IP profession, I studied and worked in engineering first, and then moving on to microengineering and nanotechnology. My colleague Dave Hall is a senior associate and IP solicitor with our litigation and licensing team. He specializes in both contentious and non-contentious IP law, and in particular, his non-contentious experience includes drafting commercial agreements, including licensing arrangements, consulting agreements, and complex collaboration agreements. So in today's talk, we will briefly cover relevant IP rights for the graphene industry before moving on to IP strategy and freedom to operate issues that impact on IP commercialization. Then we will look at IP commercial exploitation through licensing models and revenue. So before we think about commercializing IP, we need to first identify what IP assets are available to license. This step is a very important one because an improper evaluation of IP assets could lead to undervaluation or missed licensing opportunities. There are many different types of IP rights, and like Terrence mentioned, this is not an IP 101 session, so we'll just go through this very briefly. So patents protect technical inventions in terms of their function, operation, or construction. Design rights protect the visual appearance of a product. Trademarks provide protection for a brand that could form the core of a business identity. And And then you have confidential information, which covers know-how, trade secrets, and other proprietary information, which are very typical of materials companies. And IP rights also exist through copyright, contracts, agreements, and there are many other types of IP rights that are not listed here. Certain requirements must be met in order to qualify for some IP rights, such as novelty and inventiveness for patents and distinctiveness for trademarks. An innovation can be protected by multiple IP rights. For example, a new type of graphene composite may be protected by a patent for its composition and use, and by trade secrets for its manufacturing process. Now, whilst patents for graphene inventions are very common and numerous, trade secrets should never be underestimated as an IP tool. This is because the scope of what qualifies as a trade secret can be very broad and can be the focal point of a graphene company's IP portfolio. And then finally, it must be remembered that registered IP rights are territorial in nature. So for example, a US patent provides protection in the US, but not the UK and Europe, and vice versa. And so patents will be required in all territories to protect all the markets. So let's take a look at IP strategy first and how it can be used to support licensing business models. A common question asked is, why bother with IP? So in the face of the economic fallout from the pandemic, innovation is seen as being vital. I mean, being able to turn good ideas into commercial success at scale can have a transformational impact on the wider economy. However, even the most groundbreaking of inventions requires revenue or investment to become a viable market proposition. The road to success is not always clear, with various hurdles to overcome before winning the trust and backing of customers and investors. Winning business is fiercely competitive territory, as customers and investors apply a forensic approach to identifying risks and opportunities with each target. IP alone will not likely secure revenue and funding, but a weak IP position could significantly impact on valuation by as much as 70% in our experience, or see a customer or investor walk away altogether. Customers are looking for the most reliable suppliers, while investors are looking for the most lucrative returns. So if ever further evidence were required to show how IP rights can underpin a business and support a strong return, a Europe-wide study by the European Patent Office and the EU Intellectual Property Office shows that SMEs with IP rights typically generate 68% higher revenues per employee than those SMEs with no IP rights at all. So there is some real-world value in implementing an IP strategy within the business. There are many different ways of implementing an IP strategy, but for today, I will focus on action points that are relevant to graphene IP licensing. So the first action point, as you can see from the slide here, is create your IP register. Have an up-to-date central IP register ready to go at all times, and continue to update this register on a regular basis as your company grows and scales up. This register should include not only patents, trademarks, and designs, but also other forms of IPs, copyright, know-how, trade secrets, IP agreements. The idea behind the IP register is that you can not only understand how your IP portfolio ties in with the wider business, but also you have the information to react quickly to licensing opportunities. Include some basic information in the IP register, such as application numbers and the current status, as this is always the first piece of information needed for any commercial deal. For a more comprehensive approach, upload and save all published applications, granted patents, and other registration certificates to your data room. Now, if you don't have an IP register and you're not sure where to even start, then one option is to have an IP audit carried out by an IP professional. Now, for more specific requirements, you will need a specialist audits. Like, for example, in relation to trade secrets, an IP professional may review where your business currently stands in terms of awareness of the need to protect its trade secrets, what trade secrets you might have, and compliance with relevant legal provisions. And this is particularly relevant to the field of advanced materials, where trade secrets often play a very important role alongside patents. So following on from the first action point, which is to create an IP register, the second action point is to ensure that ownership is clear. So in the world of graphene, collaborations with other companies or academic institutions are very common. However, the more parties that are involved, the more complicated the IP ownership issues can become. Innovation, especially in startups, can occur perhaps before commercial relationships and business processes become formally defined, which can make assessing IP ownership less clear-cut. In more established SMEs and corporates, commercial partnerships may have evolved over time, but perhaps without the correct formal agreements in place. In our experience, failure to establish proper ownership of IP is the #1 deal breaker, because any gray area surrounding who owns the IP will signal alarm bells for a potential investor or a licensee. And rather than be faced with the question of how to resolve an inventorship or ownership dispute, which ultimately can end up with expensive court proceedings, it is much better to avoid the problem in the first place. So, which is why an investor or licensee would just walk away. So, in order to ensure clear ownership, you need to identify the inventors, and you need to establish the chain of title as early as possible in a formal, well-documented manner. It is a very difficult conversation to have, but it is even more difficult and expensive to untangle a messy ownership situation in future. So, for example, where appropriate, any assignments should be executed and registered, and there should be clear and written agreements in place for any joint ventures or collaboration agreements, and we'll touch on that later in this presentation. And also establishing a process to be followed for determining ownership during collaboration is also important, and that helps avoid difficult conversations after the event. And then back to the register, all documentation regarding ownership should be stored securely, for example, in your central data room. So with specific reference to material transfer agreements and licenses, you should keep track of what you use, where it came from, and how you're permitted to use it. And this is, for example, to avoid breaching conditions that you've agreed to. If anyone decides to do due diligence in the technology, perhaps, for example, if you're seeking investment or licensee, they will want to know that everything is above board, including ownership, because you can't license technology that you don't own. And then on to the third point, research is generally covered by agreements and licenses. But how about when your work is ready to be commercialized? Have you planned ahead? Are your licenses fit for purpose, or do they need to be updated? Has anything changed from the start which has affected the commercial outlook of the relationship? So don't assume that any existing agreements and licenses cover what you're planning to do now, because things may have changed. And then are there any obligations to anyone under material transfer agreements? If yes, who are they and what are the obligations? And again, back to the IP register, make sure you have all this information in your data room for easy access. The third action point is write down an explicit IP strategy. Now, an IP strategy is not just we will file patent applications as new innovations identified. Because this informal approach can result in missed opportunities, because new innovations may not be properly identified or not identified in time before being launched publicly, which in turn could result in missed licensing opportunities. So a key question to ask is, how are you developing new innovations? How are you capturing them? And how are you planning to commercially exploit them? The answer to these questions indicates how important IP is to your business. For example, do you have a systematic process? Are there regular meetings between the technical teams and the commercial teams with the remit of reviewing recent R&D and how they relate to the business? And perhaps if commercial collaborations are involved, the IP strategy may point to perhaps a section of a research agreement or a collaboration agreement to show that the ownership situation is clear. I mean, there are many steps you can take, but in essence, properly designed IP strategy will require a high level of IP awareness that involves understanding identifying, developing, and documenting your IP strategy, including your business plan, your commercial milestones, and any inventive concepts you have, possible protection strategy through patents and trademark registrations, and also identifying and securing trade secrets, mitigating risks of infringing third-party rights to ensure freedom to operate, and enforcing your rights and defending against third-party rights, and very importantly, your IP budget. So having this explicit IP strategy in place will help you make the right IP decisions and manage your rights responsibly, commercially, and cost effectively. And this preparation at an early stage will pay dividends in the long run when your company is approached for licensing opportunities. So as an example, this slide outlines an IP strategy which refers to innovation capture processes, educating employees, documentation of IP-related information, conducting clearance searches to ensure freedom to operate, monitoring competitors' IP rights, and making IP decisions that are aligned with the business. On the other hand, this slide outlines a more detailed example IP strategy in which specific steps are taken to ensure technology is protected through patents and trade secrets, decide how the technology is to be commercialized, perhaps by licensing, and timelines for developing improvements and raising funding, and mitigating risk of infringing third-party rights. Some of the IP strategy steps may resonate with you, while some steps may be completely irrelevant to you, because there is no one-size-fits-all IP strategy, which means careful consideration of the business is needed when designing an IP strategy from the outset. Obviously, like I said before, build a strategy around your business plan and make sure it's explicitly written down. Questions you might ask yourself: what do you need to protect, when and where? How will these rights help you to achieve commercial goals? How would you drive future innovation, and where will you focus? What type of partnerships will be most beneficial? And then finally, put yourself in the shoes of an investor or potential licensee. They will be focused on your IP strategy and your IP portfolio, and as to how it can benefit them. And if they can see the benefits of your IP strategy and IP portfolio, they will be more willing to engage with you. And then obviously with these objectives, they will always evolve, and IP strategy requires regular review to remain fit for purpose. So 3 simple action points which can be taken. Obviously, there are many other steps, but do always consider your business plan before deciding on your IP strategy. Next, we turn to freedom to operate, which is the other side of the coin from IP protection. So having a patent for an invention is not the same as having the freedom to commercially exploit your invention. This is because patents, like most IP rights, are a negative right that enables you as a patent owner to prevent others from using their patented invention. However, if your invention comprises elements that are covered by third-party patents, then the third-party patent owners can also prevent you from using your patented invention. This situation becomes even more complicated due to the landscape of numerous graphene patents that covers processes and applications, which creates this so-called forest of patents that you have to navigate through. Take, for example, this graphic. In the first instance, the large circle represents the scope of protection for your patented invention, let's say a graphene composite material. However, a competitor obtains a patent for your graphene composite material plus a new additive, for the combination of a graphene composite and a new additive, while another competitor obtains a patent for a product that uses your graphene composite material. So what happens is, whilst you can stop them from using the graphene composite material, they in turn can stop you from using their patented material plus additive combination or their patented product. So essentially, you create this issue where people are people are prevented from exploiting their own graphene innovation. So the licensing value of your graphene IP not only lies in how well your graphene technology is protected, but also how much freedom you have to commercially exploit your graphene IP without infringing third-party rights. To assess your freedom to operate, you need to do your due diligence in checking whether your proposed activity could infringe a third party's IP rights. And this is typically done by conducting patent searches and assessing the scope of patent protection. Now, obviously, these searches are not cheap and very time consuming. Our recommendation is to look at what your plans are at that point in time. So perhaps for an early stage company, extensive searches and legal opinions are probably not appropriate due to the cost and uncertainty involved. But instead, what they could do to mitigate future risks is perhaps do a basic search and then maintain watches for publication of key competitors' patents and doing pop-up searches on a regular basis. Alternatively, if a product launch or licensing deal or an investment is imminent, then a full freedom to operate investigation will probably be warranted. Doing searches early not only allow you to identify IP risks early, but it also has the added benefit of enabling you to design around any patents identified as risky. Now, but when it comes to assessing the scope of protection of patents, care must be taken when reviewing them because claim interpretation can be very complex and also can vary on a country-by-country basis. Even in the UK, relatively recent case law has indicated that the scope of patent protection can extend far beyond the literal meaning of the patent claims, which in some countries is commonly referred to as the doctrine of equivalence. So therefore, advice from IP legal professionals is always crucial when it comes to reviewing and understanding patents. But whilst freedom to operate investigations are important to identify and assess potential IP threats, it is not all negative. IP investigations might uncover opportunities for taking a license or giving a license or even cross-licensing between parties. But at the end of the day, what you do with the results of an FTO investigation will be commercial in nature. Do you spend the money and take the time to ensure that your commercial proposition is completely risk-free from a freedom to operate perspective, or do you take on significant or some risk? The complexity and cost of FTO searches often deter businesses from engaging with freedom to operate in the first place. But burying your head in the sand and ignoring the risk of third-party IP rights could result in a bigger financial loss further down the road if a patent owner decides to sue you. So at this point, I will now hand over to my colleague Dave Hall, who will cover IP commercial exploitation through licensing models and revenue, including practical tips and common pitfalls. Over to you, Dave.
Thanks very much, Jason. I think we just had a brief question in from Faiz, who's he's flagged that he's got existing IP in Malaysia. If he wants to file IP in the USA, will that be possible? We're going to be classic lawyers on this one and say it depends, but we'd be very happy to take a look at that for you. If we can get some contact details out to you at the end. A lot of this will depend on what you've disclosed publicly already, what stage of application you are currently at, how the process is being developed, who it's been shared with. So there's a lot of context here, which we definitely won't ask you to share over a Zoom chat box, but we can provide you with some email contact details and we can look at whether the USA is a viable option for you, depending on where you are. If not, there may be other things you can consider, including divisional type applications or recent developments to your inventions that you might be able to protect going forward. So we'll make sure that you've got the contact details at the end. That will come round to you. So thanks very much for your question, and as I say, hope to be able to help with that one. Brilliant. So on the models and revenue, as Jason's explained, you start with a fundamental foundation of knowing what your IP is, hopefully knowing what it's worth, and then you need to look at your IP as almost a toolbox of things that you can use to generate commercial revenue, work with partners. These things are very easily segmented. You can break down your IP through licenses into a number of different territories. You can do it into different markets. You can be as clever as you like to be with your IP licensing model, or you can be as simple as you want to be, depending on your appetite for risk and your appetite for management and your appetite for working with lawyers, which may well be less than anything else. So move on to the next slide. Thanks, Jason. Okay, so potential ways to commercialize and generate revenue from your patents, although you've got to bear in mind this also applies to your trademarks, potentially your trade secrets, depending on what they are and how you use them, and any other forms of registered IP. So you can out-license for a royalty or a fee, which is a very common way of making immediate revenue from a single product, or potentially even a single product in a single territory, as I've mentioned. Out-licensing is very common amongst SMEs because you will find that it can be more difficult to get investment on a product which has not been tried yet. So if you're at very early stages, you may find another commercial entity, perhaps in a different country, may be interested in taking your invention to market and actually effectively proving your concept in a commercial setting without requiring an immediate financial input from you, because they're willing to take the risks. They will speculate on your product for you. They won't necessarily put money directly into your business, but what they'll do is they'll agree a revenue share arrangement, which allows you to generate income and also see a product reach the market in the first instance. I did wonder when we get this question, actually, so if it's one from David, what is a typical royalty or a fee? The answer to that is whatever you can get on an open market. It is pretty much like house pricing. It may well be the best area in the entirety of London, and a one-bedroom flat will go for £800,000. What we would say is that the royalty or the fee will depend substantially on the type of technology that you're licensing, as in, is it the entire product itself, or is it a small component within a much larger product? Because depending on how that falls, you are likely to see a much, much smaller fractional percentage of the total sale value of an item if you're a component part. Whereas if you are the sole product, effectively, or the thing that adds value, and there are no other major components that are involved, you may be able to command a greater royalty because a greater percentage of the value in the end product is from your item. So if we're talking in, for example, a pharmaceutical context, if you are providing the technology for filtering through a number of potential options, testing a compound, perhaps, you may see a very, very, very small royalty or a small fee every time that testing process is used, or every time a product made where that process was involved hits the market. So you'd see fractional percentages there, or a small payment. If, on the other hand, you provide the fundamental compound, which is then simply just put into a delivery mechanism and sold, you would expect a much higher royalty rate or fee. The other relevant consideration here is what stage are you at and how much risk are you taking compared to your partner or partners that you're involved in. If you're at an early stage, you may well see an increased royalty on potential sales of your final product, but very little by way of upfront fee, because there will be little desire on the part of the other party to give you money for something which is fundamentally unproven. They would rather you share the commercial risk such that if it doesn't reach the market, they've not paid you anything in order to achieve that, given they're investing sums in development. If, on the other hand, you've done a huge amount of the development work, you've put in a lot of the finance, and you're now looking to effectively allow somebody to piggyback off that advantage, move it into a new territory, you may well be able to command a much higher revenue, whether that's by a large upfront fee to allow you to effectively recuperate some of your immediate expenditure, or a higher percentage on your royalty. So your commercial investment already will have a big sort of implication for what you'll be looking to command. So it's a very long way of saying ask for what you think you're entitled to and see what they say. And it depends on commercial balance, but hopefully that'll help with some of those factors. I mean, that's potentially, I mean, as I say, I can't talk about what the, because I don't know what the product is itself, but 3 to 5% is not a unusual royalty, for example, for product bearing a particular logo or trademark. So if the majority of the production cost tends to go through the other party, the licensee, then a 3 to 5% royalty simply for use of the trademark, which adds some commercial value, is not an unusual royalty. If you license IP, then what happens to any enhancements you make to the original IP? So that's a question from Arsheen. So the really interesting one about that is it depends on competition law and where you live. In the European competition law structure, you will find that you cannot automatically require that the licensor gets all of the IP back in improvements. So that's something you have to be very careful of. So it will very much depend on who you're negotiating with and where you're negotiating. But as a starting point, improvements will generally rest with the party that makes them. Collaborations are fundamentally helpful. They allow you to share a risk when bringing your invention to market. So you might find you agree a joint venture structure, or you agree a way of splitting costs 50-50, 70-30, 60-40 for development, and then agree a revenue model on the back of it, again, based on your IP and your developments. You could even sell your patent, your registered IP, or even your unregistered IP to an interested party. It doesn't have to be an investor. You may find that selling out at an early stage and going away and working on a completely separate venture is what you want to do. That's always an option. And then, as we've mentioned, seek third-party investment or funding based on your portfolio. But as Jason said, having a great IP strategy, having a very clear register of all your rights, registered and unregistered. So don't forget about your copyrights, your trade secrets, and other unregistered rights, because investors who are savvy will want to see these. Hold those, keep your IP portfolio if it's your major asset, and make sure that it's clear, accessible, and effectively user-friendly for investors. Okay, so collaboration in general, as I've mentioned, is a great way of sharing risk. If you're an early stage business, you may well want to access external expertise. You may want to work with a company that has some complementary experience for you. So you may have come up with something that will revolutionize an existing industry. One way that you can move forward by bringing graphene in is to work with those companies that you believe will benefit the most from the use of graphene in that particular innovation. So you can use a collaboration agreement to set out the responsibilities on either party, the benefits that you'll get, and this can really supplement or accelerate your research program, and you can gain a competitive advantage over other major players in the space. That is fundamentally one of the benefits of collaborating, and it also gives you a little bit of negotiating leverage if you're aware of, as Jason said, following an FTO, who may be most interested in the technology. So if you know there are 2 or 3 major players in the space, and they're aware that you're aware that there are players in that space, a collaboration agreement may be a very productive way to move forward if you want to keep working with your invention. As I say, collaboration will generally require input from you. It tends not to be a hands-off sort of operation. You need to contribute time, expertise, and effort in order to make that work. So it's not a low effort model, but it can be an extremely productive way of moving it forward. Likewise, you can co-develop IP and share risk and achieve that outcome at a shared cost. Just be aware of joint IP. There are issues with management of joint IP, so that needs to be very carefully considered if you think the parties are going to work together in a fairly balanced way, because there are things you can't do without the consent of the other person who was involved in its creation if joint IP arises. So just a flag there for you. What is the purpose of the collaboration? It might sound like a really basic question, but a lot of the time when we're talking about collaboration agreements, license agreements, any form of research and development arrangement, it helps to start at the end and work backwards. Where do you want to get to with your collaboration? What are you looking to achieve? What are the 3 or 4 bullet points that you would say this represents successful output of this relationship between us? We tend to put that in a heads of terms type document because it really adds clarity to the actual drafting process and the negotiation process. Because if you have to consolidate things down into short, easily understandable sentences, you need to be very comfortable with the concept, the work, and exactly what you're trying to achieve, which saves a whole load of lawyers' time and it saves a whole lot of your time as well. So start with the purpose and then go backwards. So when you're putting together your heads of terms, we've put together some bullet points here of relevant things you might want to think about, some commercial, some legal. Background IP is the IP that exists prior to the collaboration starting. It is effectively what you are bringing to the table. And before you get going, you're going to need to understand what you have, what your collaboration partner or partners have, and what you're willing to put in effectively to the mix and work on in order to achieve an outcome. So background IP is really often forgotten. Everyone gets really excited about what's going to be generated out of the collaboration. You need to remember what you're bringing in, because if you don't, there could be some really complicated conversations at the end about who owns what, who brought what to the table, and everyone needs to get their IP strategy and IP registers out again with the dates to try and resolve the issues. So think about that when you start rather than later on. Equipment and materials, manpower and financial input. Again, make sure once you know what the purpose is and you know what the project plan is, who's going to fund it, who's going to do it, if you're going to subcontract it, who's going to cover the costs of that. These types of considerations, again, put it in a framework, put it in bullet point form. Don't try and draft it out into an agreement straight away. Share it with the person or people you are working with and get agreement on it. So what does each party expect to get out of it? This is the bit at the end of the heads of terms. What's the ownership of foreground IP going to look like? What are you going to do with that IP when you have it? So rights to exploit. This will also be relevant to licensing as well. So this is very relevant. You can agree what you want to do with this IP. You can agree which party takes it to which territory. You may decide that somebody's got a better foothold in Japan, you have a better foothold in the US. Therefore, even if you have jointly owned foreground IP, one party gets a clear exclusive right to use it in one area, the other party gets a clear exclusive right to use it in another territory. Likewise, you might break it down by end purposes. One of you might want to use it in telecommunications, another one of you might want to use it in offline comms, for example. So if you do have background IP, for example, as Jason's mentioned before, you got to make sure you've got freedom to operate. So that may involve taking a license. So if one party's developed an improvement to their IP, they've done it themselves, but you think it's going to be critical for you to exploit what you've developed during the collaboration, you want to make sure you have an option to take the license to develop the end product. So even if you don't agree all this in advance, do make sure that you have the ability to sit down and negotiate these things sensibly in the event this sort of thing arises. Okay, so this is the joint ownership slide of caution. Some of you may know Marmite, some of you love it, some of you may hate it. Foreground IP is what we're looking for. It's the output, it's the development, it's the good stuff that comes out of these types of arrangements. However, joint ownership can be extremely difficult. If you have two fairly well-balanced parties who are responsive, informed, and generally on good terms, and you have a very sensible structure and organization in place with response dates, two appropriately authorized people who will agree how something works, it can be a really effective way of conducting business. Likewise, vesting it in a joint venture agreement can be a great way of actually dealing with that, and then everyone controls it through a shareholding. However, more often than not, joint IP clauses are put into any form of collaboration agreement or development agreement, and people only think about the implications of it after it's happened. And where you have a major imbalance in the size of the parties, it's really difficult because one party cannot do something without the consent and permission of the other, which means you can't sell it, you can't license it, you can't make any money out of it without the other party expressly agreeing and writing that that is what you can do. And I can imagine enough of you have had enough difficult business conversations to know that that's not necessarily a situation you want to find yourself in by surprise, particularly if there's a breakdown in sort of relationship during the course of the development or the collaboration. So Sometimes it's necessary if the work's jointly developed, but you can't segregate those out. Or if the parties agree that they both want to do it this way, that's also fine. But as I've said, you need a structure in place and an agreed way of managing it that leaves a very low risk of what we call logjam, so decision paralysis. You can't really operate IP effectively if it can just be a request that goes to somebody and there is no recourse if that person doesn't actually respond, doesn't do anything at all, and just simply sits on that request or the IP, which can be harmful for both businesses. So it's something you need to deal with very carefully if you're going to include it at all. So just a flag. Okay, so if you're going to do it, as I've said, you need to think about filing. You need to about who deals with the applications. People like Jason are experts in dealing with multiple people sending multiple comments, at which point he'll tell them he's actually come up with the right answer. So they should go with him rather than either of their opinions, which is the professional's prerogative. But when you're going to be generating IP, the prosecution process, including where you're going to file, what you're looking to cover, the priorities that you have in respect to the product claims, for example, the uses of graphene or the innovative combinations that you're going to generate, how are those going to be used? Both parties will have a view on that, or multiple parties will have a view on it. So you need to plan who is going to contribute, who's going to be the final arbiter on these decisions, and then you need to stick to that process, because otherwise, again, you can end up spending a lot of time, a lot of money in disagreement. So you need a structure in place in your IP licenses and your collaboration agreements that cover this. So those are some of the pitfalls as well. In the absence of agreement, you can work under a UK patent, but you can't grant licenses, you can't sell it either. Infringement is another major one. Usually, the person who owns the IP is the person who deals with infringement. There are other provisions around exclusive licensees having the right to go against third-party infringers. So if somebody else is infringing a patent, again, if it's joint, that's not straightforward. A litigation agreement is something you definitely want to think about if somebody else is going to infringe. Or again, you might want to break it down by territory. If it's easier for one party to enforce in the US because they're a US-based entity, then give them rights to enforce against US infringers. These things can be dealt with sensibly and commercially, but again, pre-plan it. Think about all these things up front. So, and finally, cost sharing, because obviously everyone will eventually fall out over that. So make sure you try and make that clear in advance. Usually 50-50 is a fair split, but it'll come down to contributions and perceived value. Okay, and then when you're in your collaboration agreements, so do the agreements you have grant the licenses that are required for exploitation? Jason's mentioned this before. This is very common with MTAs. It's very common with licenses to use development tools that you may have actually used to pull together your invention in the first place. Make sure you've got all of that, because if you're looking to, even as a solo entity, if you're looking to license your IP on, one thing you will always find in a license agreement is reassurances and warranties for the benefit of the licensee that you, the licensor, have got all of the rights you need in order to allow them to commercially exploit the product, capital P, or particular invention that you're granting them. If it turns out you're in breach of that, you could find yourself effectively indemnifying them when there's a third party claim against them for infringement of IP, which can be a very expensive mistake. So doing your due diligence on all of the in-licensing that you've done in the first place, all of the potentially protected tools, materials, or anything else that you've used in your early stage development, whether working with the university or another commercial party, think about that and just make sure you've got a clear picture. All part of your IP strategy, but just, always think about this in agreements. When you're looking to exploit your foreground IP or use the necessary background IP of either party to actually get this product on the market, are you going to just have an option to negotiate that? Is there a chance that there'll be no IP generated out of this agreement? Or do you want to try and put in a meaningful option and structure to allow you to negotiate an exploitation license as quickly as possible? And then in respect of academic institutions, I work a lot with companies that do research with academic institutions. It does raise a few different questions. They will often be willing to license you certain background IP in order to generate a product or to develop your own product, which you can then license out. Their concerns are generally research, teaching, and publication. Some are more commercially savvy and will want revenue or to be involved in any joint venture company and take a share of shares. But you have to be careful, because quite often publication clauses give them the right to push a publication out whenever they choose. As Jason will attest to, making sure that any developments and novel and inventive ideas remain confidential up to the point of patenting is critical. So always look at your arrangements with academic institutions and make sure you've got some control over publications. You get enough notice, you can go through and screen it and work from there. And then, so you'll see, generally speaking as well, concerns of commercial partners, patenting, and protection of know-how and other confidential information. Make sure you do it properly. Great. So licensing, generate your revenue on IP. You pass your development, manufacturing cost risks to your licensee. You can also, as I've said, as a hub in the middle of the web, push out your IP to those who have territorial knowledge and experience and access to appropriate markets. Reduces the need for your own resources or funding, but it may well reduce your revenue directly, so lower risk, potentially lower reward. So we've given you some best practice points on IP licensing here. A lot of this is consistent with the collaboration agreement points as well. Involve your legal counsel at an early stage in negotiations. Of course, we'd say that. Make sure you're operating under a non-disclosure agreement. Protect your inventions, protect your ideas, protect your trade secrets properly. As I've mentioned, heads of terms are going to be critical. Set out your commercial structure and make sure you stick to it. And what that means is it should reduce your time in drafting when you go forward. When you're looking at an NDA, it's very straightforward, really. Just make sure that it is tailored for the situation that you're working with. The purpose is a very, very important thing to cover. It sets out what you can and can't use confidential information for. Make sure it's specific, not just the parties are going to discuss a business arrangement. It may well not be suitable for that. And keep an audit trail of your confidential information so you can appropriately manage it. And then in terms of the heads of terms, we'll just leave that for you to read on the slide. I'm not going to cover that in any particular detail. It's just a useful flow chart for what you're going to want to put in your heads of terms as mentioned. Right, exclusivity is a really key question for a lot of people. Fundamentally, there is a balance of power quite often in negotiations. Exclusive licensees have a number of benefits, including being able to enforce generally against third parties who are infringing. A lot of parties who come to the negotiation table for a license will want an exclusive license because it means they get the run at a particular product or the particular territory you're offering, and nobody else will compete with them, including you as the licensor. So an exclusive license even keeps you out of the market that you allocate to them as a result of the license. So if you're licensing out, be really careful to think about whether that licensee is a well-established presence in the industry. Are they actually going to be able to generate a suitable level of revenue? And you want to do your due diligence on them to make sure that they're actually going to give you the revenue stream and the benefit that you're looking for. If they're not, a non-exclusive license is generally a preferable option because you can introduce effectively a competitor into that market to encourage them to either work harder or potentially work smarter. You can also have the ability to drop that exclusivity if they fail to meet particular revenue targets or particular sales targets during the course of an agreement, but all of that is up for negotiation. In terms of your minimum royalties and volumes, you can set a base level. Again, you have to negotiate and agree it in advance, but just bear in mind that that is potentially where protecting your interests. So sub-licensing, again, just make sure that you have enough notice and control over those sub-licenses such that you are not losing control of your technology and your IP, and make sure that your licensee is liable for anything that they do or use. And then royalties themselves, again, a lot of this comes down to accountants' language. So what is net sales value? Do make sure that you're doing this on an arm's length sale, not an internal sale between two group companies, because they may try and move things around between a group, and that is then a first sale for the purposes of calculating royalties. So be careful with your drafting, make sure it's sales at arm's length. work out what taxes, overheads, and other things may be deducted from the sums that you're taking a percentage of, but just take a little extra care to look at your net sales definitions if you're going to use that in your royalty calculations. Likewise, sub-licensees, are they going to have to pay up the chain at the same rate, or are you going to give your licensee the flexibility to choose and then still have to pay you the same amount? Consider that as a revenue stream as well. This is a question that came up actually. Improvements, the block exemptions there. So there's a little bit of text that will point you in the direction of how to deal with improvements. But again, that's a very complicated question. It's probably best answered offline. And then dealing with infringers, make sure the right people do it. You don't want to put your patent at risk by allowing your licensee to launch actions in various territories, because it's extremely common that where there's an infringement claim, there is also a counterclaim for invalidity. So you want some oversight over what is going to happen with litigation and infringement, because there may well be an, not so surprising, but an unwanted counterclaim for invalidity that might put your licensed asset at risk. So always consider that very carefully. We've got some pre and post deal steps, which we would just consider to be a light checklist to go alongside your litigation strategy. So have a read through those at your leisure. They'll be provided and they'll be on the recording. But hopefully that was helpful. I think there's a selection of questions actually, aren't there, Terence? So should we go through and see what fits?
Yeah, we have a couple of questions, and that was first of all, I want to say thank you, because we said at the beginning there's quite a volume of material to go through, and there was. And I think the context that both of you brought to the discussion was exceptionally helpful. And I hope that our audience recognizes how valuable this conversation has been, because I think it does go well beyond just a superficial treatment of the subject and talk about all these really important nuances of how to approach this subject. And when I look at the graphene companies that we've been working with now for almost 10 years, a lot of them have invested quite a bit of time, effort, and attention to developing IP, protecting their IP, and also what both of you have alluded to is a lot of this is in the trade secret realm. And I think it's less obvious for people on how to protect trade secrets. So one of the questions that we have is, what kind of documentation and what kind of protection do you need to actually categorize something and to put it into a position where it can be protected as a trade secret? What does that mean? And that of course is also internally vis-a-vis employees versus externally, how much information you share. How would you respond to that?
Yeah, absolutely. And it's a very relevant question. There's been a change in trade secrets law in the EU and the UK recently, so it's something we've looked at quite closely. The way I like to explain it in an initial way is confidential information is important to your business. Confidential information, however, is a light version of a trade secret. A trade secret is something which is fundamental to the operation of your business. If it were to be shared, it would undermine serious value, such that you'd be looking at potentially having to restructure your business or deal with a serious economic downturn. We're talking about the sort of thing that if it landed in the hands of competitors, it would give them a springboard to compete with you that would really sort of make your management board twitch. As such, the more practical elements of maintaining a trade secret are you do not allow it to have the same circulation list as general confidential information. It might be that things like the financials of the business during the course of a year would be shared with the entirety of your work employee network, if you're willing to do that, under bounds of confidentiality. A trade secret such as a key algorithm, a formulation, a particular method of manufacture would have nowhere near that circulation list. You would also have an audited record of exactly who knew about it at what point. So we operate a system and recommend a system that has a clear audit trail of who knows about the document, where is it stored, is it offline, who's had access to it, not least because when some of those individuals may leave the business, if it suddenly turns out that one of the new businesses that's a competitor in the space who also is employing that ex-employee, you have an audit trail demonstrating where that trade secret may have flowed. So you can also deal with this in your NDAs, but make sure you have a separate category, a higher security category for things like trade secrets, and things like audits will help you identify those and filter them through in innovation capture.
Excellent. I have another question for you, and this is some lesson that's often learned the hard way. I like to say that these kind of business deals are kind of like marriage. They're pretty easy to get into, but they're expensive and painful to extract yourself from. And so you want to think about, how do you exit one of these agreements if it doesn't work? So for example, if you're a company that has IP, you license it to a partner, and then they end up just not exploiting it. They don't generate sales, and then they basically sit on it. And let's say they have an exclusive territory, you're effectively cut off from commercializing that particular territory. That's just one example of non-performance. And I think one of the other questions that's in the chat boxes talks about working with a large company. What happens, if the license is granted in perpetuity, right? So things change, especially these days, quite rapidly. Can you talk about the importance of anticipating how to end these relationships? Not, everybody's eager to get into them, but I think they need to think, how do we end it if it doesn't work the way we expect?
Yeah, absolutely. I think so. There's two ways of looking at that. I think if you look at it from the perspective of being the smaller company, you'll probably see some of the things in the agreement that actually you'd want if you were the larger company. So let's look at it from the small company's perspective to start with. So if the deal allows the large company to own the IP, take over prosecution, deal with it, manage it, and then you get a license in perpetuity, the major thing to watch out for is how they then prosecute that patent, how they look after that IP portfolio, because once they own it, although there may be some value in the license down to you if you're exploiting, a lot of the value may well also be tailoring the portfolio for their benefit or the benefit of another licensee. Therefore, you're going to want to make sure, if you're benefiting from freedom to operate within the scope of the claims of a particular patent family, you get some oversight on what the filings look like, what amendments are potentially made, and if they have amended the patent or patents such that you no longer fall within it from your in terms of the product you're putting on the market, that license ends. So we have a very common thing where if there's no valid claims that cover what you're doing commercially, that is a termination circumstance. So in that particular example, that's one thing to look out for. On the flip side, as I say, key performance indicators are vital. Or use shorter term agreements to effectively encourage compliance during the course of a year. Set a target, don't necessarily give automatic termination, but if they have to report to you quarterly and you've got a 90-day termination period prior to the end of the first year, they know full well that when you get your third quarter figures, you then have the option to exercise termination, which leaves them out on their ear without a right to use. And that can be very difficult. So there are different mechanisms you can use. You can, as I say, have automatic results of failing to meet targets, or have a termination right effectively for cause, or even at your own election, such that you have a rolling agreement for the first couple of times that you're working with them. And once they've proven themselves, maybe look at extending that agreement out. So, effectively do a try before you buy.
So putting the right conditions in place to determine if the license is being executed to your satisfaction. I think exactly. That's excellent sense. There's a follow-up question, and I'll make a comment to it. The question's quite benign and simple. Do you recommend an arbitration clause? My experience, I've worked cross-border now for 3 decades. And what I've seen is, if you go to a legal proceeding, you have to get enforcement, and enforcement's another question I want to ask you guys about, is how do you actually get joy out of if somebody infringes, how do you actually get made whole? But this question about arbitration, my understanding is, and I'd love to get your perspective, is that, let's say my partner is in France and I'm in Singapore or whatever, and they infringe and I need to go to France to get a legal proceeding. I may or may not get joy. I may not get paid out of that. However, if there's an arbitration clause, arbitration agreements, there are some universal agreements for enforcement, and it might actually be easier to enforce an arbitration agreement than it is a legal proceeding. Am I correct?
Yeah, so absolutely. So subject to reciprocity is what we consider. So it's international treaties. Some of them apply across all states in Europe. So if you get a decision in one state in Europe, you will generally get that decision enforced in another state, particularly in relation to IP, I'm talking about here particularly. However, that is not the case between, for example, the US and Europe. Now, the nuance here really is around what are you disputing? I'm a massive fan of arbitration for various reasons when it comes to dispute around performance of a contract, what contract wording means, and whether somebody's complied with it. Because A, arbitration is fully confidential. You're not looking at a published decision. Nobody sees your dirty laundry when you have to tell everyone exactly what went wrong and why. It's all kept under the hat. Arbitrators are very, very useful for that. And as you say, there are international treaties confirming that an adjudicable award can be enforced anywhere in the signatory treaties areas, and that includes China, the US. There's a lot more signatories to that than most international treaties on IP litigation. That being said, there's a couple of drawbacks. Number one is arbitrators are generally not experts from a technical perspective. You would have to work very hard to find the right technical experts if your question is fundamentally technical, which quite a lot of IP litigation can be. So if we're talking about third-party infringement or the definition of a particular patent claim, you're going to want to rely on an expert court or an expert judge, really, which is why we like the UK, because there's expert IP judges who are all scientifically trained, generally PhD or sort of doctoral qualified. You may well struggle to get that with arbitrators. And the other thing is immediate satisfaction. So what we call equitable or injunctive relief. So what I like to do where we've got a contract such as this or an IP license, if arbitration is sensible, because both parties are operating in different jurisdictions, want to agree something neutral and then allow mutual enforcement of breach of contract, great, we'll use arbitration. But we'll also allow for the right for a party to seek injunctive relief, which allows a very quick resolved court decision, so obtaining an injunction to prevent somebody from doing something they're not supposed to do. Arbitrators can't do that, so we tend to allow for the right to do that alongside. And cost-wise, fairly comparable on the whole, but you'll generally see fewer procedural steps with arbitration than you will with the court, but general rule.
Excellent. I'm going to ask just one more question because I think we've covered quite a bit here. Let's end on a high note. And we'll talk more about a commercial aspect. There's a question here, and I think the answer you actually gave it earlier when you talked about the pricing and how do you value this. That's the $1 million question. Sometimes literally the $1 million question. What's the value of my IP portfolio? What's the value of my patent? And the way this question is posed, it says, since the most valuable item is the final product, that's where the full value is realized. If you're a producer of a raw graphene material that enhances such a product, how do you avoid being devalued? Basically, is I'm paraphrasing. How do you avoid being devalued as just a material supplier, and how do you benefit more from the end product? And I would say this question is as relevant to the licensing question as it is to how much graphene companies should charge for their material, because there's very little price discovery. And because there's little price discovery in what the value of graphene is, the market is still sorting that out. It relates directly to what's the value of the IP, right? Because if you can't sell the product for X, how do you value the IP that goes along with the product? And I think your answer was, and again, I'm going to try to summarize, it's another term for it is value-based pricing. What's the value of your contribution to that value chain in the end product, and work backwards to figure out what can the customer or the licensee afford to pay for this IP license based on how much profit is embedded in the end product. And if you're a licensee, the same question is, what can you afford to pay a licensor to add graphene to your product or your application? And I think a lot of times people don't look at it that way. They do a cost plus, or they think we've had all this investment, or our material is special, therefore we should get a premium. And in the reality, it's what's the commercial sustainability of the pricing. Is that kind of like the right view? Do you have the same view? Because you guys see this all the time with licensors and licensees.
Yeah, no, absolutely. And I think it's something that is thought about a lot in FRAND licensing. So for standard essential patents and whether or not the rate should be the same for everything. So everyone needs access to this chipset. Should it be the same for every single product? Now, quite commonly, you'll find market knowledge will help you hugely in this particular negotiation. So knowing your customer, knowing their business, and knowing what they sell at the end is going to be critical to how you value what your license is worth. If you're going to provide a component that is the difference between them being able to produce a $600 a go product or not being able to produce it at all, then your IP is going to be extremely valuable. And the way you produce it to a certain level of purity, to a certain level of thickness, to a particular malleability that allows them to use it in the product, if that is your USP, you can keep the process as a trade secret, or you can potentially patent it, depending on your approach. But look at the value that you're adding to their final product. If they're selling a very low cost product, but in high volume, but fundamentally your production processes are relatively expensive, you give a high purity, then you need to think about, well, can they produce this slightly cheaper product with any other lower grade, cheaper, or otherwise? If the answer is they can't do it, then you're still justified in claiming a greater proportion of the end cost, because if fundamentally you're facilitating the difference between getting on the market and not, then you might be looking at a higher total percentage, or even just a fixed amount per product, which represents the difference between them being able to make a sale and not. And again, if you're a small part of a very, very big composite component product, you got to realize you're arguing against people who are providing full chipsets like Qualcomm, for example. If they're only taking a 3% royalty for an entire chipset and you're providing an interface material, you might expect a slightly lower royalty. So know your end customer well and know your value proposition.
Yeah, I think that's excellent advice. As we summarize here, I just want to let everybody who's listening know the Graphene Council is an independent, neutral body that helps to bring these partners together. We work with universities, including technical transfer offices. We work with investors. We work with large multinational end user companies. We work with graphene producers, of course, and intermediary companies. The Graphene Council helps companies to commercialize their IP portfolios. We can help them commercialize their inventions, their material, and their applications. We do not participate in the IP itself. We do not take a percentage, and we do not have a commercial interest in any of the graphene companies. We remain a total neutral party who provides advice within our scope of expertise. And I want to thank Potter Clarkson, and in particular, Jason and David, for the excellent, helpful, insightful, actionable information that you guys shared today. This part is so important. And I think, especially small graphene companies or innovators in any sector, they struggle because many times they're scientists first, business professionals second. And when it comes to the legal aspects of how to actually protect and exploit what they have, it's a distant third, right? And so I think having knowledgeable experts to help navigate this, because it's a shame to get 9/10 of the way and you fall down on that last tenth because you don't know how to either exploit or protect what you've developed. So I want to thank you both for that. And if you had any closing comments, those are welcome.
Absolutely. Just thank you for the opportunity. It's good to speak to you all about it. And as I say, I think taking a bit of time and thinking about your commercial out at all points during your development, I think is just a really useful ready reckoner. Start with your end in mind. The development's an exciting process, but think about your output and work backwards from there would probably be my one tip.
Thank you. Jason?
And thank you, Terence. And just to echo what Dave has just said, it's all about your outcomes and preparing towards those outcomes. Preparation is key when it comes to IP law, and it's because often you can't cure a messy IP situation. So it's all about preparation. And because, like Terence said, many graphene companies are founded by scientific founders, so we do often forget about the IP side of things. But yeah, thanks, Terence, for inviting us to talk about graphene IP.
Well, thank you. And we're proud to have Potter Clarkson as one of our member organizations in the Graphene Council. And if any of you are not members of the Graphene Council and would like to know more, please reach out to us. We're here to help navigate this whole sector and make it a vibrant industry sector. And thank you for joining. We always appreciate it and wish everyone a safe and successful rest of your week. Thank you. Take care.